I want to welcome everyone to this discussion on the Wastewater Systems Effluent Regulations and wish everyone a happy new year. Though I know it is trying times, and I do appreciate everything that everyone is doing. My name is Deatra Walsh. In case you haven't heard my voice before, you don't know me, I'm the Director of Advocacy and Communications with Municipalities, Newfoundland and Labrador. Yeah, so let's get started. Basically, I arrived at MNL in the summer of 2019, and this was a big file at that time, and we're going to talk a little bit about that in a second. And I'm so happy to be providing you with updates today. When we initially sent out the invitation to this meeting, we said there was a couple of main purposes here. We wanted to provide an update to members on the MNL wastewater file. We were going to discuss any preliminary questions associated with the discussion document, proposed amendments to the Wastewater System Effluent Regulations. And Tobias has already put some links in the chat window to that document and others. We did share links initially when we shared this invitation as well. And the final purpose of this meeting was to hear from members regarding ongoing wastewater concern in their municipalities. Now, I want to make sure that I tell you what this meeting is not. This is not a public consultation. I'm not consulting with you on behalf of Environment and Climate Change Canada. We are having a meeting amongst ourselves right now to revisit this topic, and so that I can tell you where things are at from an MNL perspective and introduce you to some of the things that are happening. This is also not a technical briefing on the proposed amendments document. Again, we've shared some information, and I'll talk about it in a few minutes. On public consultations that Environment and Climate Change Canada is doing, and they will be able to walk you through, and they will walk you through that amendments document. However, toward the end of my presentation, I'll point you towards some key things that you should keep in mind as you're working through the document itself and this process. And there's a couple of key takeaways. As I say, I came on here in 2019. This was a really important file. Of course, you know, the conversations about this preceded me being here. And if you've been on council or involved in the municipal sector or working in these operations, you'll know that this has been a big issue for quite some time. So it's a really important opportunity right now to become familiar with the proposed amendments discussion document, to read it, to see what's in there. You know, to have staff who are responsible for wastewater infrastructure be very familiar with it, for folks on council, as well as folks who are responsible for the infrastructure files on council. Also, it's so important. We have a golden opportunity now that we have been asking for, and I'll reiterate why this is so great for us. But we have an opportunity to engage in this consultation process, and not only to engage in it, but to actually impact national policy as it relates to wastewater systems. This is what we've been asking for. This is the opportunity now. And I really encourage you to take in the presentations, the public consultation presentations that Environment and Climate Change Canada will do, to fill out the online feedback form, and we'll share links to that as well. And really, most importantly, is to ask questions, to work toward compliance, and also to not be afraid if you haven't been compliant, if you've had interactions with enforcement, or if you're not monitoring, or if you've not been engaged in this before. Don't worry, but now is a time that we can do this kind of engagement work. And I'm here for you to navigate this process. Environment Canada, there's some fabulous staff there that we've been working with. They're there for you. And what we really want to do is work toward compliance, and also really work toward the goal of why these regulations came into force in the first place. That was to reduce the amount of toxic substance going into oceans, and to really help our coastal environments. So, I think we all can agree that that's an important goal. So let's try to get there. I know there's obstacles, but that's why we're working through these, and that's why we're here today. So just in case you're wondering, and this may be questions that people have, We've shared some links already, but at the end of this meeting, I will share links to the effluent regulations in an email to those who are participating. I will share the proposed amendments document, the public consultation meeting invitations, a specific NL consultation meeting invitation. I'll share that as well. I'll share the online feedback form, the link to that, and I will share the slides from this presentation. Of course, we are recording it, so you'll have access to it as well. I say all this, if you're furiously taking notes and you're worried about not catching everything, it's my job to make sure you have all the information you need. If you didn't catch something here, I'm going to share it all afterward. I'm hoping that this will all be very clear to you, and we'll certainly share the audio and the video as well, so you can revisit it as well. All right. I want to start with the most important piece of information, and then I'm going to jump around a little bit. This is the document that I keep referring to, the proposed amendments to the Wastewater Systems Effluent Regulations. And this document was released on December 6th. We sent out a note about it to inform you that this had come out. We then shared a link, and we encourage you to have a look at it. There are some key pieces in this, and this is why I keep saying, please read this. It is not an extensively long document, very clearly written and accessible, and really makes sense. The staff at Environment Canada have worked really hard to make this document meaningful for the communities who are most impacted by these regulations. There are two key areas that I'm going to speak to at the end of my presentation, and that's the proposed areas to be amended. 3.1, transitional authorizations, and 3.3, the key administrative improvements. Now, some municipalities are impacted by temporary bypass authorizations, but they are far fewer in Newfoundland and Labrador, in fact. And this document is really the reason why we're here today. But before I get back to all that and dig a little deeper, oh, sorry. Couple of key things as well. Just to note, there's the public consultation dates, and we've shared information around those. We'll share them again. There's one happening tomorrow from Environment and Climate Change Canada at 1:30 Eastern Time, and then another one on January 25th. There's one in French on February 10th, and there's one in English on March the 1st. If you can't make one of those public consultation dates, that's okay, because we will have a Newfoundland and Labrador specific consultation date, and that will be happening on Thursday, February the 3rd at 11 o'clock Newfoundland time. We will send out a link to that meeting invitation so that you can register for that as well. Suffice to say, there are 5 opportunities to engage in these public consultations, one of which is specific to Newfoundland and Labrador. Please make every effort to attend one of these public consultations, and indeed make an effort to be there with us on February the 3rd. And again, that will be Environment and Climate Change Canada who will lead that, and that will be a public consultation event. So those are some of the key pieces of information to keep in mind. But, you know, I think it's important for us to, for new councillors, for new staff members, for those who've been on council before, and for staff who've been involved in this topic for quite some time, to review a little bit, how did we get here? You know, we're sort of in the middle of something right now. We're in a process. There are documents in front of you, but how did these documents come about? Why are we talking about transitional authorizations? Why are we talking about administrative pieces? Why are there amendments? And if you're wondering that, don't worry, you may not be alone. That's why I'm going to do a little bit of a timeline. I want to take the opportunity to run through a short segment of this history to jog your memory and to recap for those who may be new to the file. So here's a bit of a partial timeline. The Wastewater Systems Effluent Regulations became registered as law under the Fisheries Act in 2012. Now, there was a lot of activity preceding that, and that led to these regulations coming into being. I'm not going to cover that in this timeline, and certainly Environment Canada has materials on that and can speak to that as well. But at that time in 2012, these came into force. In fact, we had an AGM resolution in 2012 that spoke to the need for recognizing the cost of implementing these regulations and the burden associated with that. And that was put forward by our board of directors to the AGM in 2012. Within these regulations, there was obviously the recognition that not all communities could comply with what was in there as of 2012. So there was a bit of a grace period for implementation, particularly around transitional authorizations. And again, this is all outlined in that proposed amendments document as well. But a key note of this was the 2014 deadline to apply for a transitional authorization. So I just want to read a little bit from the document on this, just in case, again, if you're new to this file or thinking about, okay, remind me of what a transitional authorization is again, Deatra. So it says, while most wastewater systems in Canada were capable of achieving the effluent standards in the regulations, a number of systems were unable to achieve the required level of treatment. Understanding that upgrading or constructing new systems was important. Of course, there was I've lost my page here. There we go. Requires extensive time to plan and finance. The regulation allowed owners operators to apply for a transitional authorization if their system was not designed to meet effluent limits. So owners and operators had until June 2014 to collect data and apply for this transitional authorization. And depending on the level of risk, a TA, as we call it, offered an extension period to the end of 2020, 2030, or 2040 to comply with the effluent limits of the regulations. So municipalities, communities had the opportunity to apply for a transitional authorization if that applied to them. And of course, in 2015, the quality standards came into force. Only 3 municipalities in Newfoundland and Labrador applied for a TA who were eligible for one. When we were looking at the data later on in terms of who was in compliance, there were approximately 10 municipalities of all of our municipalities who were in compliance with the regulations. So we recognize there were a number of reasons for this. I won't get into those reasons, but suffice to say that by the time I arrived in the M&L world and in 2019, this was getting to a crisis, given that many of our members were not in compliance with the regulations. They could see no way to do so, and enforcement had begun. So if you may have been at our emergency meeting in 2019, where we had 150 folks gathered from municipalities, including staff and council. We invited our 7 MPs at the time. Staff from Environment Canada there came as well, and we wanted to talk about the issue at hand. And here's a picture of of the MPs at that time at that meeting, and our then president, Tony Keats, the mayor of the town of Dover. So at that time and in that meeting, what we were asking for were 2 things. We knew our municipalities needed time because many of them weren't in compliance, and many of them who were eligible for transitional authorization had not applied, and we needed money. We knew, and you know, that the cost of putting these systems that were required into place were simply prohibitive, and they weren't possible. So one of the solutions that we had on the table at that time was in fact to reopen the transitional authorization window, to enable that to happen so that we could actually get more time to plan and to finance the systems we needed. And of course, we had proposed solutions around the need for money as well, which included several things like permanently doubling the gas tax. Again, this is something that FCM talks about quite frequently, or indeed coming up with targeted infrastructure funding for wastewater systems. But the thing we needed the most was time. After we had that emergency meeting, a lot of advocacy happened. Many of you wrote letters to your MPs. We met with federal officials. We did a lot of work with Environment Canada to see what was possible. And again, there were a lot of people advocating on your behalf. So thank you once again for all that work and all of that advocacy. We also put forward, where 2 resolutions were put forward during the AGM in the fall of 2019. One from the Board of Directors, therefore be it resolved that municipalities, Newfoundland and Labrador, lobby the Government of Canada for a revising of the wastewater system effluent regulations to extend the period of eligibility for applications to obtain transitional authorizations, again, reflecting this idea of needing more time. There was also a resolution from the town of Marystown. Therefore, be it resolved that municipalities, Newfoundland and Labrador, approach the federal government and, on behalf of all municipalities in Newfoundland and Labrador, lobby for an amendment to the regulations that would allow for the termination of monitoring of wastewater systems that have already been categorized as medium risk and high risk following the first year of data collection, which will reduce monitoring costs and allow those funds to be utilized towards future treatment solutions. I'd like you to keep those 2 resolutions in mind, because when we go through the document a little bit later on and point out some key areas, you'll see that our advocacy and your advocacy has had a huge influence on this process. And some of these pieces around needing more time and reducing administrative burden are currently on the table for amendments. So let's go back a little bit to the timeline. We did all that advocacy work, and then we found out in 2020 that the federal government was actually going to open the regulations for consultations and start an amendment process. So the notice of intent to amend these regulations was published in the Canada Gazette in June of 2020. These kinds of things don't happen very often. We influenced national legislation. We were able to get that happening for us. We noted in the communique to you early on, this is unprecedented. So this is something to celebrate, and this is part of the process we're in now. And this is why it's so important to be engaged. We asked for this to happen. It is happening, and now we can really impact it going forward. So you'll see there, the discussion document was published in 2021. And of course, now we're already into 2022, and we're getting into this public consultation process up until March 6th. And there's feedback happening on the discussion document, feedback that we'll provide and that you'll provide. How's everybody doing? Good? All right, thumbs up. Any questions in the chat? How's the chat going? Because I can't see it. Anything burning at the moment, Kathleen?
No, all
okay.
Quiet. Front.
All quiet. Everybody's listening. All right. Thanks, Kathleen. I appreciate it. So I just want to talk a little bit more about what we heard from members and some of the things we know. So really what we've heard all along is, not only are the cost for new infrastructure is prohibitive and, in many cases may not make sense for future communities, particularly smaller ones, but this monitoring burden is simply too great, especially for smaller communities where effluent levels are not changing. We heard from many of you that, it was excessive, the amount of monitoring. We'll talk a little bit about the costs in a while, and certainly the resolution from Marystown in 2019 reflected that. There's a huge cost to monitoring, and many of you said these are costs we could use towards capital, toward the infrastructure that we actually need to put in place. So that's some of the larger things that we heard. And in the spring of last year, 2021, we did some work on a municipal census project, and I want to again thank all of the administrative staff who participated in this census project. There were quite a few questions there, a lot of information that we asked for, and you took the time to do that. At the end of the day, we had 107 municipalities represented in that data set, which is actually quite good. And some of the quick facts on wastewater and sewer systems as it relates to, WSER and other things from that census project included that, more than 75% of households in our municipalities are hooked up to the municipal sewer system. For the most part, those systems are definitely in excess of 20 years old. I'm sure that that's not going to come to you as any surprise. Over 40% of respondents indicated that their municipality does not have an operations, a preventative maintenance schedule for their sewer system. Over half of the municipal outfalls represented among that group are going directly into the ocean. This is not a surprise. We already know this. Environment and Climate Change Canada knows this. And slightly more than 60% of municipalities represented in this sample are monitoring their outfalls. And 45% of those municipalities own their own monitoring equipment. 43% of them are renting the equipment, and 56% monitor by contracting out. And we know that many of you work with contractors to take on the monitoring task. And you can see we asked about the cost of monitoring as well. And that cost can range anywhere from $3,000 to over $50,000 a year. Again, huge costs when you're talking about your bottom line and your budgets. And, again, we know that the cost to meet the WSER requirements as they previously were quite great. We asked about that, and estimated costs ranged from $75,000 to $78 million for individual systems just to have upgrades. We heard from smaller municipalities who were saying, we've got a small community and it's going to cost estimated $6 million for the kind of treatment plant that we need. So, there are some huge funding hurdles here, but the first piece we knew we needed to get at was indeed dealing with the time, compliance, and ensuring that our members are compliant and that you are compliant as it relates to providing data, as it relates to transitional authorizations. So I want to return to some of that now. So again, as I said, I'm not the writer of this particular document. I don't have a deep understanding of what went into the writing of this, and I can't provide a technical briefing on it. But what I want to do, as I mentioned earlier, is just to point you to some key areas that are meaningful and important for us at MNL and related to the pieces that we were asking about before, and that is the transitional authorizations and the key administrative improvements. So what I've done is I've pulled out some pieces from the document and I've highlighted it just to draw your attention to that. So the new transitional authorization process, basically in this case, Environment Canada is looking to amend the regulations so that municipalities and communities who are eligible for TAs can indeed apply for a TA now. There are some details about that is quite important for you to have a look at. But as I note in the highlighted area there, and I know it could be quite small on your screen, and so not to worry, like I said, I will share this presentation with you. But it says here that based on the feedback received in early engagements, Environment Canada is proposing a flexible approach using an open application period with no deadline to apply. This would enable the use of monitoring data already submitted under the regulations. And there are in fact 106 municipalities who are registered in ERIS, which is the data registration for monitoring. And this would enable the use of the monitoring data already submitted to apply for a transitional authorization where there is eligibility to do so. More than 90% of communities that would be eligible to apply for transitional authorization are already reporting data under the regulations. So again, you may already be, and many of you are submitting data under ERIS. But this approach, they say, also provides a window of opportunity to any new systems requiring a transitional authorization in the future. For wastewater systems that are new to reporting and are eligible for a TA, they would monitor and report to ECC for at least 12 months. We know that some of our municipalities, and this is also through the census data, have never monitored and likely have not submitted data. So we need to engage a little bit more with those members as well to determine what they need, if they are in fact eligible for transitional authorization, and to get that monitoring process in place. There is a piece there on revising ammonia sampling requirements, so this may be applicable to some of you. Environment Canada is proposing to allow flexibility for owners and operators to demonstrate that ammonia is not a risk factor through either a limited number of tests for ammonia, the use of historical data submitted, or from indirect factors that may indicate ammonia is not an issue. And for those of you who are deeply into the technicalities of this, this will likely resonate a little bit more. I am less well-versed in ammonia testing, I have to be honest with you. So that's the key piece on the transitional authorizations. You know, they are proposing that a window of opportunity be open, and that it be flexible, and that it be a rolling application. But in order to receive a transitional authorization, you do need a year's worth of data. And for many of the municipalities and our members, those data are already in place. And I'll refer to the annex again, though I've mentioned it before. Many of your outfalls indeed are placed already in a proposed timeline for your TA as it relates to this particular amendment. The other thing that I want to point you toward right now in this document is this piece on the key administrative improvements. And this is particularly relevant for our members, especially smaller communities. Environment Canada is proposing to address various operational and administrative challenges that have arisen during the course of administering the regulations. One key piece on here is on consolidated systems. So under the current regulations, owners and operators are allowed to consolidate 10+ outfalls as one future system. What they're proposing is to allow owners and operators to consolidate 2+ systems as one future system, as long as those outfalls will become a single wastewater treatment plant. And what they're noting is that this will allow more owners and operators to use the consolidation provisions. It reduces administrative burden by focusing monitoring and reporting to the outfall with the largest volume and largest potential risk to the environment. Owners and operators could better allocate their resources to upgrade their system rather than monitoring multiple individual outfalls. And again, thinking back to what our asks have been, what your asks have been, and the advocacy that we've been talking about, this directly speaks to reducing that burden in a way that makes sense. Related to this, the monitoring and reporting provisions, there's a piece there on clarifying and simplifying administrative provisions, including optimizing monitoring and reporting for small systems holding a transitional authorization. So keeping in mind that once you receive your transitional authorization, there's the opportunity for you to simplify the administrative burden. And really what Environment Canada is proposing, that small systems, which many of you have, granted a transitional authorization, they would only be reporting on an annual basis, not necessarily on a monthly basis, which is what's required now once you get a transitional authorization. And that's regardless if they have a continuously or intermittently discharging system. It's also reviewing other testing, monitoring, and reporting provisions. And this review is intended to streamline existing provisions and reduce regulatory burden. And once again, this has huge implications for our members and really reflects the kinds of things we've been asking for. The final piece that I want to just alert you to, and that we've noted up until this point, is the Annex 1 in this document. When we released some earlier communication on this, I said, please take a look to see if you can see your outfalls in the annex and where they are placed. So, you know, in that annex, at the end of the document, Environment and Climate Change Canada actually lists the systems with the 2020 deadline that are likely not eligible based on a proposed approach. They have the systems that are eligible and expected to receive a transitional authorization to the end of 2030 and again for 2040. And there's a final list there of systems that may be eligible for transitional authorization, but have not provided enough data to be assessed. I strongly encourage you to look through that list and see where your outfalls are. if you have multiple outfalls, some may fall into the 2030 list and some may fall into the 2040 list. But your first task is, if you haven't already done it, to go and see where they fall. I want to be clear. Everyone will still have to apply. There will be an application process. You won't be just given a date. There will be an application process, and that will be dependent upon data and agreed upon with Environment and Climate Change Canada. But at this stage right now, this is where they're expecting many of the outfalls to fall. And you need to be aware of that. And if you have any questions about these things, especially if you're on the 2020 deadline in that listing, I really encourage you to reach out directly either to me or to Environment Canada right away. It's important to communicate with them. It's important to ask questions. They are there to help us and help you navigate it as well. And we are as well. But as I say, it's very important to sort of see where you fit in this category, in this listing. All right. That's the end of the presentation portion. A little bit longer than 15 minutes, so I'm off by about 10. I know there was some intense information there. Whoops. Go back. Sorry, folks.
And we have had a couple of questions come in just at the tail end of the presentation, Deatra.
Perfect. So before we get into those, Kathleen, I just want to remind everyone, sorry about that, technical things, buttons pressing, and you get to the next slide before you intended. But I want to remind you of the key takeaways from this. Again, this was intended to be an opportunity for us to come together, for me and for MNL to provide you with an idea of where we're at right now. And the key takeaways, please become familiar with this document I'm talking about. Please get engaged in the consultation process. Take in the presentations. Like I said, one is happening tomorrow. There's several others happening throughout the next couple of months. And we have one specifically for Newfoundland and Labrador on the 3rd of February. Fill out the online feedback form. And as the folks at Environment and Climate Change Canada have said to me, ask questions. If you're worried, if you haven't been monitoring and you're wondering, or it just seems like too big of a problem to take on and you're concerned about that, reach out and ask questions, either to me or to them. We have to get compliance can happen. We just have to communicate with one another, and we have to get everybody on side. And I really do believe in this process. I think we have a huge opportunity here, and we're here to work with you, and Environment and Climate Change Canada is here to work with you as well. So I'm going to leave it at that. And I just want to thank you so much for signing up today.